the central government is going to release the notification with respect to the establishment of the Central Consumer Protection Council. So the main objective of the council is to protect the rights of the consumer. Under this Competition Act of 2002, the government will not be having rights to interfere and to restrict the companies from competition against any other company. Hello everyone, I'm Arun Kumar, lecturer in Department of Commerce and Management, Vidhyaashram First Grade College, the Temple of Excellence, MYSURU. Dear students, welcome to this new session, session number 4 on unit number 3, that is Competition and Consumer Laws. Yes, what and all we discussed in the previous session? Yes, we discussed about what is district forum, what is state commission and what is national commission, and who is going to appoint as a district forum president, who is going to appoint as a state commission and the national commission, and what and all the qualification they are supposed to obtain to become a president of district forum, state commission and also the national commission, and who is going to appoint those presidents and other members of district forum, state commission and the national commission, and in what situations they are going to be disqualified as the members or as the president of the district forum, state commission and the national commission. So this and all the topics what we discussed in the earlier session. In this session, we are going to discuss about the few more topics with respect to the Consumer Act 1986. So what we are discussing now, we are going to discuss about consumer protection councils. Yes, other than the district forum, state commission and the national commission, we also have this consumer protection councils. So what does it mean? What is this consumer protection council? So consumer protection councils have been set up at national and state levels. Yes, this consumer protection councils are set up in the state and the national level. Here you can see the state and national levels. Their object is to protect rights of the consumers. Yes, the main objective of consumer protection councils is to protect the rights of the consumer. That means what and all the rights a consumer will be having, those rights will be protected by the consumer protection councils. What and all the rights you will be having as a consumer, like questioning about the product, checking the quality of the product, checking the quantity of the product, finding any defects and recommending any suggestions about the product. These are all the rights what you have as a consumer, as a purchaser of the product or the service. Provisions with regard to consumer protection councils are contained in the Consumer Protection Act wide section 4 to 8. Yes, with respect to the protection of rights of the consumer, this provisions regards to the protection of consumers. The protection councils are contained in the Consumer Protection Act wide section 4 to 8. That means the provisions with respect to this consumer protection councils, those provisions comes under section 4 to section 8. Central Consumer Protection Council. So it is establishment of this council by a notification of the central government. Yes, this Central Consumer Protection Council is going to be established by the notification of the central government. So who is going to release the notification about this Central Consumer Protection Council? Yes, the central government is going to release the notification with respect to the establishment of the Central Consumer Protection Council. Next, the central government nominates government and private members from different departments and sectors. Yes, once the Central Consumer Protection Council came into existence, then the central government is going to appoint the government people and private members from different sectors, from economic sector, from commerce sector, and from law sector, from different sectors, they appoint different members of the different departments and from different sectors as the members of the Central Consumer Protection Council. Next, at present, there are 150 members in the council. Yes, at present we have 150 members in the Central Consumer Protection Council. Totally, how many members we have? We have 150 members. Chairman of the council is Central Government Food and Civil Supply Minister. Yes, who is going to be the chairman of this Consumer Protection Council? Yes, the Central Government Food and Civil Supply Minister. The minister who appointed as a Civil and Government Food. Okay, the person who appointed as the Government Food and Civil Supplies Minister, that person is going to be the chairman of the association. Next, 3-year terms of office of council. Yes, 3 years of term of office of council. The people who are going to appoint as the Consumer Protection Council member, their tenure will be 3 years. Next, if any post of the council falls vacant, it shall be filled up by a same cadre member. That means, in case if a person is retired from that particular council, then the person will be having the same qualification, same eligibility. The same person is supposed to be filled for that particular position. Next, 3 meetings are compulsory in a year. Time and place is fixed by chairman. Yes, this Central Consumer Protection Council, they are supposed to conduct minimum of 3 meetings in a year. How many meetings? Minimum of 3 meetings in a year, and the time and place of the meeting will be decided by the chairman, and it will be intimated to the members of the council, and all the members are supposed to be compulsorily attend the meeting, all the 3 meetings in a year. Next, the main object of council is to expand and protect the right of consumer. Yes, so the main objective of the council is to protect the rights of the consumer. So what and all the rights they are going to protect? That is, protection against fatal advertisement of goods for human life services. Yes, the protection against the fatal advertisement of goods for human life services. So sometimes some advertisements are not going to, compete with the whatever the product. The product and the advertisement one are not relevant each other, but still what the company will do, the company give the fake advertisement and it attracts more customers. So in that scenarios, this council will be taking the action against those particular suppliers. Next, protection against improper trade transaction and services. If proper trade is not happened between the buyer and the seller, if the council is going to feel that the seller is doing some illegal activities, if he is doing some colorable activities or colorable statements, then at that time they'll be taking the action against this particular improper trade transactions. Next, as far as possible, a right of satisfaction about the various qualities. Yes, sometimes if the customer satisfies with the products, then what he will do, he goes on purchasing the same product for the longer period. If he is not satisfied with the product as a customer, what you will do? Yes, obviously you will not continue to purchase the product, rather you look into some other brand products, right? So here the particular customer will be having all the rights to satisfy with the product, and as a council they are going to advise the companies to give a good qualities of particular products in order to satisfy the needs of the consumers. A right of belief and confidence on goods and services. Yes, they protect the right of belief and confidence on goods and services, and also a right of compensation against misbehavior in restricted trade policies. Yes, in case if some particular transactions or if some particular trades are restricted, even though if they are trading beyond that, then the authority or the council will be having all the rights to put some fine on them and to give compensation for the customers. Next, a right of consumer education. Yes, a right of consumer education with respect to the product, their quality, quantity, packing, labeling, pricing, everything about the product. So these are all the main objects of the council to protect the right of the consumers. Next, State Consumer Protection Council. So we discussed about the National Consumer Protection Council. Now we are discussing about State Consumer Protection Council. Establishment of this council by notification of state government. Yes, this council will be established by the notification of the state government. That means state government is going to release the notification about this state council, State Consumer Protection Council. Next, chairman of the council is the State Minister of Food and Civil Supplies. Yes, the council chairman is going to be the Minister of Food and Civil Supplies. Next, state government nominated governments are private member from different sectors. Yes, state government nominated government are private members from different sectors. So who are all going to be the members of this state commission or the State Consumer Protection Council? Yes, the state government members as well as the other sector members, other private sector members. Together, they are going to appoint different parties to be the members of the State Consumer Protection Council. And there must be at least 2 meetings in a year or arranged according to convened any time. That means minimum they should conduct, at least minimum they should conduct 2 meetings in a year or more than 2 as per their convenience they can conduct. But conducting of 2 meetings is must and should, and the date and time of the meeting will be given by the particular chairman of the State Consumer Protection Council. Next, date and place of meeting shall be fixed by the chairman. Yes, as I said, the date and time will be fixed by the chairman of the council. Next, object of the council is to protect the interest, and rights of consumer in the state, which is the same as central council. Yes, the main objective of this State Consumer Protection Council is to protect the rights of the consumers as we discussed in the Central Consumer Protection Council. Next, the Competition Act 2002. So this is completely a new topic. So far we discussed about the Consumer Act 1986. Now we are discussing about the Competition Act 2002. So what is this Competition Act 2002? So the history of Competition Act 2002. So there will be n number of companies. At present we have n number of companies for the same kind of product. For example, shampoo, right? For shampoo we have more than 30 to 40 different companies. So sometimes to become number 1 in the sector, in that particular department, they go for any extent, right? So they may not follow the rules and regulations formed by the Competition Act. So this Competition Act is to have a control on the competition between the companies and to bring the healthier competition between the companies and to make sure about the quality of the product which is reached to the consumers. So the history of Competition Act 2002. Justice K.C. Das Gupta, a Supreme Court Justice, oversaw the establishment of the Monopolies Inquiry Commission. The commission's goal was to learn more about the impact and scope of monopolistic and restrictive trade policies in the significant Indian economic sector. The Competition Act 2002 is an act or law that guarantees free and reasonable competition in the business and prohibits any ineffective or unnecessary interference by the government. So earlier we had this monopolistic market. What is this monopolistic market? So monopolistic market is nothing but monopolistics. So what is this monopolistic market? Monopolistic is nothing but one seller. One seller, that is only one seller. Whatever the price he will tell, you are supposed to pay that much of price and you are supposed to purchase. And what kind of product he will give, you are just supposed to accept it. Okay. In that scenario, no competition, no healthy competition, no reasonable price, nothing. So what happened? Then the thought of bringing the competition between the companies. How they bring the competition between the companies? By encouraging more companies to start business. So here you can see the Companies Act, the Competition Act 2002 is an act or law that guarantees free and reasonable competition. Yes, here any company can come and they can compete with any company. There is no restrictions at all. Okay, and there is no restrictions at all. They can come and they can compete with any company in a business and prohibits any ineffective or unnecessary interference by the government. And here, under this Competition Act of 2002, the government will not be having rights to interfere and to restrict the companies from competition against any other company. Next, the Competition Act 2002, the Monopolies and Restrictive Trade Practices Act of 1969 was replaced by it. Yes, this particular act, that is the Monopolistic and Restrictive Trade Practice Act of 1969, is replaced by the Competition Act of 2002. Its definition was flawed and too primitive to prevent wealth accumulation in a small number of hands and monopolistic practices. Parliament approved the legislation in January 2003 and then revised it in 2007. The primary goal of this Competition Act 2002 is to establish a foundation for creating the Competition Commission. Yes, overall this Competition Commission 2002, when it came into existence in 2002, afterwards it got amended in the year of 2007. Okay, but still this act will be called as Competition Act 2002, and the main object of this Competition Act is to bring the healthier competition between the companies who compete each other and to avoid the government to interfere in the business and to make free competition between the different companies and to create a healthier competition and to create a demand for the product and to sell it in the market, and also to make sure that the customers will get guaranteed and quality products with a reasonable price. And the next thing is definitions under Competition Act 2002. So the definitions given under the Competition Act 2002 are as follows. So few important definitions are given under this particular Competition Act 2002. So which are those definitions we have under this Competition Act? So the first definition is acquisition. So what is the meaning of acquisition? The agreement to directly or indirectly acquire shares, voting rights or assets authority over any firm is referred to an acquisition. So acquisition is nothing but acquiring of the shares or voting rights of any company is called acquisition. So what is acquisition? Acquiring of or receiving or acquiring of the shares or voting rights of any company's assets is called acquisition. Next, what is cartel? So cartel is nothing but an organization of manufacturers and sellers that restricts control over the distribution, sale or advertising of commodities by previously negotiated agreement. So cartel is nothing but an organization of manufacturers. It's a organization of all the manufacturers and sellers that restricts the control. It restricts the control over the distribution, sale and advertising of commodities by previously negotiated agreement. That means they'll be having the control on the sale and distribution and also on the advertisement of commodities by a previously negotiated agreement. That means whatever the agreement is done, the particular advertisement or sales or distribution should be according to that. If it crosses, then this particular organization is going to have a control on it. That is called cartel. Next, position. So position is nothing but a dominating position as a company's strengths in the relevant market, and it gives the business freedom to operate and the power to sway the market in its favor. So position is nothing but a dominating company, a company which acquires more area, that is called position. And any company who is having the position, they can trade freely in the market and they can be the leader of the market, and the market in its favor, the market will be in favor of that position company, where the company will be dominating the other companies and where the company will be standing first compared to the other companies. That is called position. Next, predatory pricing. So what is predatory pricing? It is the practice of artificially driving down the cost of products and services to prevent competition. Yes, to prevent competition with the competitor, what we are going to do? We are going to bring down the cost of products and services. So in order to compete with the competitors, we are going to bring down the cost of the products and the services. That is called predatory pricing. Next, rule of the reason. So it analyzes a course of action based on its commercial, rational and effects on the consumers and the competition. So rule of the reason is nothing but it analyzes a course of action based on its commercial, rational and effects on the consumer and the competition. So here, based upon the consumer and the competition, the rule of the reason is going to be decided by any company or by any organizations. So these are all the definitions, important definitions. We also have few more definitions with respect to Competition Act 2002. We will discuss it in the upcoming sessions. Until then, thank you all. Have a nice day. Namaste.